All right, Mr. Lewis, before we take up any preliminary matters, let's have the DA call the case.
Sure, Judge.
With the defendant here before the court, Your Honor, this is State of Georgia versus Javier Alexander Michaux. We're here for a preliminary hearing in regard to warrant number 21W03851, charging the defendant with 1 count of battery family violence, and warrant number 21W03852, charging the defendant with 1 count of cruelty to children in the first degree. And representing him is Attorney Lawrence Lewis.
Okay, Mr. Michaux, I'm Judge Jerome. This is your preliminary hearing. We may have some preliminary matters to take up before we have your hearing, but I do want to advise you of a couple things. We are holding this by video, by agreement of all parties, and we are doing that to keep everyone safe because of the virus. Now, I'm in an open courtroom. Normally, the public can come in and out and observe proceedings. They can't do that in this case because we're holding it by video. So the way we make it available to the public is we stream it live on YouTube. All right, so I tell you that just to give you a couple instructions. At any point you can't hear us during the proceedings, just hold your hand up like that and we'll get it fixed for you. And two, we don't know who's watching the YouTube feed, so be careful how you react to testimony. You know, a lot of head nods, hand gestures, eye rolls, even mouthing words. We don't know who's watching and what they'll make of that, but I do know it cannot help you, it can only hurt you, okay? All right, Mr. Lewis, I think you had a preliminary matter?
Yes, Judge, preliminarily, I was appointed on April 21st, 2021. I received a call from somebody that identified themselves as my client's fiance. I went out to see him on the 23rd. It's a very short meeting. He indicated that he would be, he indicated he had retained counsel. He didn't give me a name, but that was fine. So I closed out the case and that was that. And then I got a notice yesterday at 3 o'clock that I was to be on the Zoom this morning. Of course, I didn't have any other prelims on, but this one, and realized, oh, we hadn't retained a lawyer. I called back the fiance that I had spoken to on April 21st, yesterday, about a month later, because yesterday was May 20th, and she informed me that they had not retained a lawyer. So I guess the first real inquiry, Judge, is to inquire of my client if he intends to retain a lawyer and wants to have a continuance so that he can retain a lawyer, or does he want to go forward with me now, or me later?
All right, hold on one second, Mr. Lewis. Can we unmute jail court for a minute? Good morning, Mr. Xavier. Can you pronounce your last name for me?
Michaux.
Michelle?
Michaux.
Michaux, excuse me. Mr. Michaux, you heard what Mr. Lewis said. Have you retained other counsel, or do you wish to retain other counsel?
I was told that somebody was going to retain a lawyer for me. That's why I initially told Mr. Lewis that. But me not knowing what was going on, then I also was told that I didn't need a lawyer. So I knew I needed some type of representation from me. Knowing what's going on, I would love to have Mr. Lewis, be my lawyer if he's still willing to do that. And I do apologize for what I was told. I was going off what I was told because I didn't know about this whole situation. I do need his counseling.
Okay, Mr. McCall.
So, Judge, can I ask one question? Does he want to go forward today with a prelim and a bond motion, or does he want me to come back out and see him? Because I haven't seen him in a month and we really didn't go over any facts or anything. So the question is, I mean, I'm fine going forward. I mean, it's not a homicide, it's a cruelty to children. But it's up to him, does he want to go forward today? Or does he want me to come? Does he want to continue the case for like 2 or 3 weeks when I come back out and talk to him?
I would love to continue today.
Okay, that's fine. I'm ready.
Yes, sir.
All right. Well, you're in good hands with Mr. Lewis. He's been here a lot.
Yes, sir. Yes, sir.
All right. I'm going to mute your video, sir. All right. Mr. Wynn, you can call your witness.
Yes, Your Honor. The state called Officer Samantha Pellegrino.
Oh, it's Pellegrino, that one. Okay. All right. Hold on. You can swear your witness.
Yes, Your Honor. Officer, if you can raise your right hand. Do you swear affirm any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put down your hand. And if you could, please state your name for the record.
Samantha Pellegrino,
And officer, how are you employed?
Wilburn Police Department.
Okay. Are you post certified?
Yes, sir.
Are you the officer who took out the warrant in this matter?
Yes, sir.
And can you tell us the facts that lead you to taking out the warrants?
I had arrived at Mr. Mush's wife's home because at the time she said that they were married and he said that they were married but separated. She had stated that he came to the home, got upset with their son and herself, and came at them, and that had beaten them up, and I could see the mark of a shoe on her son's leg. And she had bruises on her hands and she had marks on her neck, and she said that he had thrown him to the ground and he had kicked their son. And after getting statements from them, I had called the defendant and talked to him, and he said that he had gone to the home, but they hadn't had any kind of physical altercation. It had all been verbal, and that he wasn't living in the home anymore, and he had just come to pick up some stuff. And then a few days later, I had gotten a call from the wife saying that she wanted to drop the charges and that she was asking if they had already gone to the state and that if the charges could be dropped because she no longer wanted to go forth with it. And I told her at that point it was up to the state and that we would go from there.
So you took out the warrant based on the wife information to you, is that correct?
Yes, also the physical evidence I had seen.
Okay. Could you explain more on what the wife told you about what the defendant did to her and the son?
Yes, she had said that he had grabbed her by the arms and had shoved her, and she was trying to protect her son, and was like on top of him, and they were being pushed into the wall, and that they had fallen to the floor, and he had kicked them several times in the stomach and made contact with her son's leg, and you could see the outline of the shoe on the son's leg. She said that there was a dog crate in the corner as well that had been smashed in, and I had seen that, and there was marks on the wall, and they had just moved in. They didn't really have any furniture in the home, and there was marks up all on the wall in the corner where she had said the altercation had happened.
And the outline of the shoe on the son's leg, is that as a result of the defendant kicking the son?
Yes, she said that he was wearing boots, and you could see the outline of the boot on his leg.
And did this happen in Gwinnett County?
Yes, sir.
And did you ever make contact with the defendant?
Yes, sir.
Okay. And is that defendant here in the courtroom here today?
Yes, sir.
Could you identify him?
He's on jail courtroom video 3.
Okay, let the record reflect that the officer did identify the defendant. And I have no further question, Your Honor.
Officer Pellegrino, how old is the child?
I believe he was 14, 15. I'm sorry, it's been a minute. I didn't get the chance to go in the office and look again.
Okay, all right. Mr. Lewis?
Okay. Good morning, officer. In the report, it indicates that the child was 16 years old. Is that
16. Yes.
Okay? That's fine, and we'll go off the warrant. That's fine. I understand that. So, the only thing I'm going to ask when you use the pronouns he and they, I sometimes get confused when you say they had just moved in. When you said they, are you talking about the mother and the 16-year-old, or are you talking about my client, the mother and the 16-year-old? Who's the they?
The mother and the 16-year-old.
Okay, Okay, good. That's fine. That's fine. We'll clarify it. My client was not living at the residence. Is that right?
Yes, sir.
Okay, so my client was told to come to the residence. Is that right? Or did
Yes,
it just
sir.
pop up?
They had a preset where he was going to give, because he had keys to the home and a garage door opener.
Okay.
And he was going to give that back, and he was going to pick up some stuff because they had both said that he came and went from the home, but he was living with someone else in a different county at the time.
Okay, so he may or may not be married to the woman that you spoke to, but he definitely doesn't live at the residence.
Yeah, he didn't live at the residence, but he was the ex. They both said that they were separated.
Okay, that's fine. They share the biological son who was 16?
Yes, sir.
Okay, did you speak to him?
Yes, sir. He was quite shy, but he showed me where he had been kicked, and he told me what had happened, and his mother's story and his story were pretty accurate together.
Okay. Well, tell me his story about what occurs when he and my client end up meeting some kind of way, whether the 16-year-old comes home or my client comes to the house. What happened?
He came in the house, and they.
He who?
I'm sorry. The defendant came.
Okay.
They had said he had been driving a white truck and that he was drunk. And the 16-year-old son had said that he was always drunk and that he hit them when he got drunk, and that he had come into the home and was upset about having to give the keys back, and they just got in a verbal altercation that escalated, and the father, the 16-year-old, the mother, and the defendant had all started. The 16-year-old hadn't really started yelling, but him and his mom, the mother and the defendant, had gotten into an argument, and the 16-year-old was trying to stick up for his mom and got in the middle of the altercation.
Okay, and then the verbal altercation turned physical.
Yes, sir.
Okay, but you were left with the impression it was based on the fact that my client was intoxicated and was angry about something that related to his having to get back the keys. Is that right?
Yes, sir.
Okay. You had a chance to speak to my client. He wasn't on scene, but you spoke to him on the cell phone. Is that right?
Yes, sir.
All right. I'm assuming it wasn't some type of Zoom call or whatever it is, FaceTime or whatever. So all you could really hear was his voice. Did you hear? Were you on the line? Were you on the line when the judge had some questions for my client before the prelim began?
Yes, sir.
Okay, so you got to hear him speak. Is that right? Okay. Yes. So when you, if you can recall, when you compare his speaking to his speaking over the phone that night after he identified himself, did it sound like he had slurred speech the night of?
He sounded irritated. He sounded I can't recall about the slur. I know he had gotten upset with me and of the situation and was telling me his side of the story, but he had said that he had been in the home, but that he no longer lived there and he wasn't trying to cause any trouble or anything like that.
That's fine. And I'll get into the story for a second. I'm just trying to understand this whole intoxicated thing. How long were you on the phone with him?
Less than 10 minutes.
About 10 minutes. Okay, good. And he's irritated. So, and you know he's irritated because he's actually talking. He's not just on the other end listening. He's talking. Is that right?
Yes, sir.
Okay. You don't recall there being any excessive slurring where you were like, oh, he's clearly drunk. You don't recall that. Is that fair to say?
No, sir. He talked in circles, but I do not recall.
Okay. What he said may not have made any sense, but how he said it didn't tell you, oh, he's clearly drunk. Is that right?
Yes, sir. I wasn't
Okay.
person with them. No.
That's fine. That's fine. That's fine. So let me ask this question. What did he tell you led to the argument itself?
Mr. Lewis, why is that relevant to probable cause?
Well, Judge, the I don't know if we're going to call her the wife. The grown female has given a version, and obviously the court gets to judge at some point in time the credibility of certain things. We're going to get to, because I think it's pretty fair to say that there were no serious injuries. Nobody ended up seeking any sort of medical attention. I think that would have already come out. So we'll get to that in a second. So the question is, what we know her version. We sort of know the son's version because the officer indicated that he was very shy. And so now we get to, did my client give a different version than the version that they gave?
All right, so you're asking for credibility purposes?
That's correct. Credibility of the female witness that the officer's spoken to.
Okay. You can answer the question, officer.
Okay, can you repeat the question? Sorry.
The question is, what was my client's story about ultimately what led to the argument between him and the wife? I'm gonna call her the wife for now, the wife.
Okay. That she started talking to him about getting his stuff, and he said that he was working on it, and that she had accused him of being drunk again, and that it had just escalated from there.
Okay. At any point in time when you were on scene, was there medical attention that was sought?
No, she said that they would drive themselves to the hospital.
Okay. Did you ever learn if that actually happened when they called back when she called back, as your testimony was, to drop the charges? Did she indicate we went to seek medical attention, or we did not seek medical attention? Did she indicate that at all?
No, sir.
Did she indicate, were there any photos taken of any injuries to either her or the child?
Yes, sir.
Okay, and what were the injuries that you documented on her?
I documented marks around her neck and marks on her hands.
Okay, and she attributed those marks to the exchange with my client, is that right?
Yes, sir. She has stated that it started with the grabbing of her hands and her arms.
Okay, and the marks on the child. I heard about the footprint on the leg. Is there any other photos that were documented of injuries to the child?
No, sir, I do not believe so.
Okay, when we talk about things that may have been smashed or trashed in the house, we're talking about the crate, the dog crate. Was that documented?
No, sir. She didn't want anything to do with the property damage. She just wanted the physical altercation marks on her body and her son's.
Okay, and how soon after you responded that day did she call and say she wanted to drop the charges? Was it the next day, 3 days later? When was that?
3 days later.
Okay, thank you very much. No further questions, Judge.
Mr. Wynn, any redirect?
No, Your Honor.
Judge, I apologize. May I ask one question? We know the child's 16. I don't know the height and weight of the child. Do you know the height and weight of the child, officer?
He's about 5'11" and about 160, 70 pounds.
Okay, so it's relatively large. And do you recall how well, you hadn't seen my client?
No, I have not seen your client.
Okay, all right. No further questions. Thank you. Thank you, Judge.
Actually, I have few more, Your Honor. Also, did you ever pull out a GCIC or a driver license on the defendant?
Yeah, it shows a picture and it shows his height, his weight.
Okay, and you used that information to identify him today, is that correct?
Yes, sir. He's the same person that was in our GCIC picture.
Okay, no further question, Your Honor.
All right, can this officer be excused?
Yes, Your Honor, state rest.
Thank you, officer.
Thank you.
Mr. Lewis, anything for the defense?
Judge, I don't have any evidence to present to the court, and I don't have any argument as to the charges as they currently are before the court. I would like to be heard on the issue of bond, though, Judge.
Okay, before you make that motion, I'd like Mr. Wynn to read the criminal history, if any.
Yes, Your Honor.
Sure.
Criminal history-wise, in Georgia, he does have a driving with suspended license in 2012, a marijuana possession misdemeanor in 2013, driving without a license in 2017. It seemed like he had a fugitive from justice arrest in Georgia. There was some charge based in Virginia. 2019, abandonment of dependent child. He does have a pending 2020 DUI and endangering of a child DUI in Bucks County. In Maryland, he have a 1994 sexual offense in the 4th degree. It was sexual abuse of a minor student. 2006 assault in Maryland. In regard to his Virginia history, Your Honor, 2017 he have a drug possession. 2018 a DUI.
All right, thank you, Mr. Wynn. Mr. Lewis, do you want to make your motion or reserve?
Oh, no, I'm going to make the motion now, Judge. I'm going to swear my client in.
All right, okay.
Javier, would you raise your right hand?
Well, before you swear him in, let's get him unmuted.
Oh, sorry, Judge.
Sorry. Can we get unmuted? Mr. Lewis, before you swear him, if you could advise him of his right not to testify, and I won't.
That's fine, Judge. Javier, two things are going on. It's my intention to call you as a witness on your own behalf to answer some questions to persuade the judge that the judge should, in fact, grant you a bond. Do you understand that?
All right, we can't hear him. Unmuted. It's unmuted, but we can't hear him.
Yeah, you're going to have to lean forward.
Yes, sir.
Okay, good. Okay, good. You're going to have to lean forward and make sure you're not coming at the computer at an angle. You got to come face straight onto the computer. You understand that?
Yes, sir.
Okay, good. Ultimately, if you testify, you're going to be sworn, testified. Prosecution is going to have a chance to cross-examine you. You understand that?
Yes, sir.
You answer my questions, you're going to have to answer the prosecutor's questions. You understand that?
Yes, sir.
Okay, good. If in fact you answer questions and the prosecutor can prove later on that you're not telling the truth, you can have perjury charges leveled against you, even if the cruelty to children charges go away. You understand that?
Yes, sir.
Okay, good. If in fact they determine that you are telling the truth, they can use the statement from today against you at a future hearing. Do you understand that?
Yes, sir.
Okay, so understanding what's in your criminal history and understanding that I suspect that you want to get out of that green jumpsuit and leave 2900 University Parkway, I suspect you want to have a bond hearing today. Is that right?
Yes, sir, please.
Okay, fantastic. Okay, good. So,
Mr. Lewis, let me add just a couple of things to that, please. Mr. Michaux, if for whatever reason, and Mr. Lewis did a great job explaining, essentially the risks of you testifying. If you choose not to testify, I do not make any negative inferences from that. It is your absolute right not to testify, okay?
Yes, sir.
So with what Mr. Lewis has explained and what I've added, do you wish to testify?
Yes, sir.
All right.
okay,
All right.
good. And I also want to add this. I want to think it's very important. I cannot make a proffer. I cannot say my client would say because I don't know enough information about you because of the whole I'm going to retain a lawyer thing. So if you don't testify, I don't think there's anybody that can testify as to your bond hearing. Now, that doesn't mean we won't have a bond hearing in about 2 weeks over Superior Court, but it won't happen today. You understand that?
But the bond hearing won't happen today?
It won't happen today if you're not testifying because I don't know enough about your situation to tell the judge on my own. You understand that?
Yes, sir.
Okay, good. All right. So is it your desire to testify?
Yes, I do.
Good. And you've already been sworn in. So give us your full name.
He has not been sworn yet.
Oh, sorry, Judge.
Okay.
Raise your right hand. Do you swear affirm the testimony you provide in the case of the state of Georgia versus Javier Alexander Michaux will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, yes, sir.
Okay, fantastic. You can put your hand down. What's your full name?
Javier Alexander Michaux.
Okay, and how old are you?
I'm 46.
Okay, and how far did you go in school?
I graduated college. And I
Okay.
Okay. I'm sorry.
That's fine. That's fine. We'll take our time. Once you start talking, I'll stop talking because the judge has to be able to follow both of us. So it's not an issue. You graduated college where?
At Lincoln Technical School.
Okay. All right. With what degree?
HVAC.
All right. Good. And then you got some post-college. Is that right?
Yes, sir. I also went to school at St. Augustine College to play basketball. I played scholarship basketball.
Okay. Good.
Second semester sophomore.
Okay, all right, and prior to your arrest earlier this year, 2021, you were employed in what capacity?
I was a maintenance supervisor.
Where?
In Griffith, Georgia.
All right, are you able to return to that job?
I can if I wanted to, but I had plans this summer to start my own employment, my own company, doing HVAC, light electrical, plumbing, and little concrete and commercial concrete.
Okay, was that full-time employment that you had with the company that you worked for?
Yes, sir. Yes, sir. Absolutely.
When was the last time you worked for them?
About like a month and a half ago.
Okay, so prior to your arrest, had you already given notice? Excuse me, that you were leaving?
Yes, I did.
Okay, that's fine. And at the first 5 months of this year, you lived where?
I lived the first 5 months of this year. I lived in 4760 Duration Court with my twin brother.
Okay, is that in Griffin?
That's in Snellville.
That's in Snellville.
Yes.
Okay, good.
Henry County.
All right, good. You and your brother lived there together?
Yes, him and his wife and his kids.
All right, good. And if in fact you were granted bond, would you return to that address?
Yes, I will.
Do you know if he owns that home or if he rents?
He's only renting to own, I guess.
Okay, that's fine. It's my intention to ask the judge for a bond amount of $5,000, and that's probably going to require about $600 for you to bond out to a bondsman. Do you understand that?
Yes, sir.
Do you think that family members may be able to put that together over the course of the next few weeks to bond you out?
Yes, sir.
Okay, good. So let's deal with this criminal history. I heard a bunch of stuff in a bunch of different places. So let me deal with the last 5 years. Have you been arrested? That means silver bracelets placed on your wrist anywhere in the United States or abroad in the last 5 years?
Yes.
Okay. When was the last time prior to this that you were arrested?
That was Virginia, and then this last situation where my shooter got loaded in Butts County. I'm dropping my son off.
Okay, so let's take our time. Butts County. You got arrested in Butts County for what?
They were saying that I had a DUI, but I had my sugar was low. I was taking my son home after getting a haircut, and that's when they saw like a hole from Clayton County, but they also put the DUI. But I wasn't drinking. I passed the breathalyzer and all that stuff.
Okay, that's fine. So you arrested for DUI in Butts County. The hole in Clayton County. Had you ever been arrested in Clayton County?
Yeah, that was for reckless driving.
Okay, the driving offense. All right, good. You indicated that you had gotten arrested out of state in the last 5 years. What was that for?
That was in Virginia. I was riding with somebody that had something and didn't take the charge, so both of us got charged the same thing.
Okay. That could be a dead body. That could be stolen jewelry.
That was drugs and possessions of drugs, a possession of cocaine in his middle of his truck, and he didn't take the charge, so all of us got charged for it.
Okay, good. Is that charge still open?
No, it's done and over with. They put me on non-reporting probation. I'm on I think the last 3 months of it now.
Okay, so you pled guilty to that charge, even though it wasn't yours.
Yes, I had to.
Okay.
It was something else.
Okay, and then you're on bond on the DUI. Is that right?
No, the DUI. I think it was. I didn't have this. I think it was a OR or something like that.
Yeah, OR means bond. That means own
Oh,
recognizance. That's fine. That's fine. That means that you're on bond. Okay, good. So, what else had you been arrested for? Clayton County's resolved.
Yes, Clayton County's done, and the only thing that I'm got in trouble for is the end of this Virginia probation. That's the last 3 months of that.
Okay, good. So, any other arrests in the last 5 years?
No, sir.
Okay, good. Felony convictions. Do you have felony convictions?
No, there's through that Virginia thing. That's the only one. And then after this probation over, it's supposed to get knocked off.
Okay, so that might be some type of first offender that you pled there.
Yes, sir. Yes, I never had a felony before. Never.
Okay, good. All right, good. I suspect if the judge grants you a bond, my request is for $5,000, just so the judge has a number to work with. If he grants you a bond, one of the things he's going to say, you can almost guess it, right? That you won't be able to drink. Since he's got some DUI in the past and he's got some allegations of you being intoxicated, you're not going to be able to drink at all. You understand that, right?
No problem. I'll do that.
Okay, you also understand that the judge may say that you're not to have any contact right now if he grants you a bond with the woman that called the police and or your 16-year-old son. For the meantime, we may be able to go later on for no violent contact since she wants to dismiss the charges. But for right now, he may say that you're not to have any contact. You understand that?
Yes, sir.
Okay, so with those two conditions, are you able to follow those two conditions? I will not go to the QT and frequent Budweiser, XOXO, no drink.
I will not frequent QT, package store, anything.
Okay, good. And you can't have any contact with them directly or indirectly. You understand that?
Yes, sir.
Okay, good. Hold on a second, the prosecutor. He may ask you some questions. Thank you, Judge.
Mr. Wayne?
Yes, Your Honor. Mr. Michaux, so you are not employed at all right now, is that correct?
Excuse me?
You are not employed at all right now, is that correct?
Something popped up. I couldn't hear you, sir.
Are you employed currently?
Yeah, I mean, with my own company, but I mean, I don't have active no contracts right now as the moment. Since, right before the season started, I was putting bids in, but I couldn't reply back to the bids since I've been incarcerated.
Okay, that's fine. And that address you live with your twin brother?
Yes, sir.
You pay rent or anything?
I do help out with rent when it's possible on a couple of bills when I am. But primarily, that's he does take care of it. That's what I do contribute.
Okay, and is your name on the lease or on the rental agreement at all?
No, sir.
Is your name on the bills or anything like that?
No, sir, not at the moment.
Okay, no further question, Your Honor.
Let me ask this question, Judge, if I may. Javier, is your name still associated with the house where your son resides?
No, not really. There's no bills or anything in my name.
No, the actual residence. I don't know if she's renting or owning, but is your name associated with that?
No, sir.
Good. Okay, good. I just wanted to make sure. Thank you very much. Now, I have no further questions for him, Judge. I don't have any other witnesses, only argument.
Judge, are you following?
It says judge left.
Yeah, I think.
He said, I've had enough. Take this job.
That's what happens. You get Lewis up there, man. Problem's the judge, y'all.
He ran the bit with.
I've had enough. Goodbye.
Seems like Miss Thomas is the host now.
That works for me. Garfon Miller, you have bond.
Yeah.
That works for me.
If Miss Thomas is the host, then you can get them all ORs.
Whatever you say. I know Garfon Miller has bond. You guys are doing an awesome job. Keep it up.
If this is still recording, this could go viral next. This could be the next thing.
I'm okay with that.
Right.
21-year career. This is what I'm known for.
Well, exactly. Well, Attorney Lewis, I was just grateful to see you show up as a defense counsel this morning, because every time I turn around, somebody that was a defense counsel yesterday, good ones too, they show up and end up wearing different suits, different color these days. I'm glad you still haven't gone over the other side, the dark side.
No. I had a prosecutor.
Nam did it a long time ago. He used to be criminal defense, right?
I had a prosecutor tell me years ago that I'm like a feral cat. I can't come back inside once I've been hunting outside. Once you eat wild birds, you can't eat cat food no more. I've never had this happen. This has been going on for like 14, 15 months. I've never had the judge cut out.
Yeah,
Me either, on Zoom. With Zoom, I've never had.
That's a great sign. Today is my day. I'm all for this. This is a great, this is the type of energy people tell me I bring. I bring blessings and prosperity and the unknown. So today, guys, you look awesome. Your clients will be exonerated or whatever the word is, but this is going to be a great Friday. Happy Friday.
Happy Friday.
Happy Friday. Garfon, you come home, son.
Be careful, Ms. Thomas. Be careful.
Okay.
You can get accused of...
Okay, I'm going off here. I'm going back to work. Bye-bye.
Personating a judge.
Oh, no, I'm not. I'm just a regular lady. No.
I see Officer Doherty's in the wings, so we should be able to go and, another...
No. I'm a project manager, no judge. Project manager.
Okay, all right.
They may give us a different feed. We'll see.
Yeah. Well, he's the host, so if the judge try to get back in, she has to let him in.
I need to let him in, you said?
Yeah, if he's coming in.
Okay, I'll pay attention.
That I've never seen before.
Let's look and see what I have up here. I don't see any alerts. Participants. He's not under participants. I don't know.
If he comes back in, I think he's going to come back in as probably Bloom.
Yeah.
Okay.
Christina Bloom. If he's trying to come back in.
Okay.
This is bizarre.
Understood.
Yeah, I don't think he's going to come back in on his name. I think it'll be Bloom.
Yeah. So Ms. Thomas, who's a witness on bond for mine, is the host now?
Yes.
Yeah, so she have control of the feed.
I am the bomb.
Huh.
Okay.
There he is. He's coming. He's coming now.
Okay, he's the host again.
Sorry about that, everyone. The internet was not ready. Okay. I got it. Thank you. All right.
So I didn't hear you say anything, Judge. I made my argument, and then I thought you were contemplating, and then I thought you just quit. Like, I'm done with this.
All right. So the last thing I heard, your last question, Mr. Lewis, was the connection to the house where the alleged victims were residing.
Yeah, so my client explained that he wasn't on the house. He didn't rent the house. He wasn't in any way had any bills associated with the house, Judge. That was his answer under oath. So I think that was the last question that I had asked him, and we didn't know you were gone by then. And so that was the last question I had for him. I don't know if the prosecutor had any other questions.
No, I think I already asked all my questions.
Judge, I don't have any other evidence. I only have argument. Obviously, you already know I'm going to ask for a bond amount of $5,000. I offer that as a number. My client has indicated that he has a brother. He has connections here to Georgia. He has been working in Georgia. It's his intention to stay in Georgia. So if the court says, no, I'm not comfortable with 5, but I'm going to set 10, the amount obviously is in your hands. What I'm asking the court to do is actually set a bond. You've heard that he's had some contacts. He has 0 felony convictions. I know the prosecutor indicated there were a number of things going on. The matter out of state with the drugs in the car, that's been resolved. It sounds like it's been resolved with first offenders, so he doesn't have any felony convictions. He's got an open DUI. But he's sort of explained the DUI, even though I didn't really need a big explanation. So it seems as if he's having contact with law enforcement, but there's no, I'm not seeing any particular theme where, you know, he's violent or he's not doing what he's supposed to be doing or he has any failures to appear. So I'm going to respectfully ask the court to set a bond amount of $5,000. Obviously, the conditions, I can almost guess them, that he is not to consume any alcohol, and that he is not to have any contact with his 16-year-old son and or the mother of his 16-year-old son. Obviously, the court may also determine that he's not to have any firearms since this is a domestic situation. But I would ask that the court still set a bond for him so that he might be able to, as an HVAC person, as May turns into June and HVAC start to go out and people need the services, I would respectfully ask that you grant him a bond, Judge.
All right. Mr. Wynn, state's position?
Your Honor, state would ask Your Honor to deny bond, given his history, especially history with alcohol intoxication, and this case is involved alcohol intoxication. He is a risk to reoffend. There's also a significant risk of the defendant intimidating the witness, his ex-wife, and child, also influencing them. There's also a big risk, a significant risk of flight, Your Honor. He has no connection to Georgia. He doesn't own the home, he doesn't rent the home, he does not have a job here. It seems like he's bouncing from here in Virginia. There's a risk of flight. There's already a charge for fugitive from justice from Virginia. From here, based on a charge in Virginia. So, based on the factors, Your Honor, he is a risk to reoffend, risk of intimidating witness, and risk of flight. And with those reasons, we ask Your Honor to deny bond.
All right. I will grant bond in this case. Mr. Michaux, listen, alcohol's not your friend, right? You're a big dude. You know, I was looking at the Warrant app. You know, you can't. It just does not help you, and your alleged behavior in this case. Generally, I would deny bond in this, but it sounds like you're trying to get your life straight. You're starting this business, and I wish you luck in that. Mr. Lewis read my mind. All those conditions are going to apply. No alcohol, no drugs, no weapons, and no contact with either alleged victim. When I say no contact, no alcohol, no drugs, no firearm, those are absolutes. I know that Mr. Lewis has made the point for now, you may not have contact. That is until another court says differently. Okay? You think you can do those things? All right, you can just nod your head if you hear me. Okay. All right, I'm going to set bond in the amount of $8,000 along with those special conditions.
Thank you, Judge.
All right. I think that concludes this hearing.
Thank you very much, Judge. Have a good weekend.